Today, we're diving into a really fascinating legal case. It pits a homeowner, representing himself, against a corporation. And here's the kicker. This battle wasn't really won on the evidence, but on the rules of the game, on legal procedure.
$305,000. That's not just a number. That's the amount of home equity that was on the line. It was the entire stake in this high-pressure legal fight between homeowner Jeremy Bass and a company called DPW Enterprises. So let's get into it. We're going to break down how a series of really strategic legal moves and some super strict procedural rulings ultimately decided the fate of this property. It's an incredible case study on just how complex foreclosure litigation can be.
Okay, so the conflict really kicks off when the plaintiffs, DPW Enterprises, file something called a motion for summary judgment. Now, their goal was simple. They wanted a quick, decisive win to get the homeowner, Jeremy Bass, out of the house without ever having to go through a full trial.
So what is this thing? Summary judgment? Well, think of it like a legal shortcut. It's designed to be efficient, to clear out cases where the facts seem really straightforward. But, as we are about to see, it can also create these massive hurdles, especially if you're someone trying to navigate the court system all on your own.
The plaintiffs, DPW, they built their entire case around a really powerful legal idea. It's basically a shield designed to protect people who buy properties at foreclosure auctions.
And here's the key. This legal shield is meant for buyers who are, for lack of a better word, innocent. Buyers who have no idea that there are problems with the sale. If they have notice, if they know about issues beforehand, that shield is supposed to just disappear.
And this is where their strategy was pretty brilliant. They pointed to these specific Idaho laws and basically argued that they had an ironclad defense. They said, look, once we have the deed from the trustee, the sale is final. The court can't look behind it, no matter what Mr. Bass is claiming.
But Bass, who again was representing himself, he wasn't about to back down. He launched this multi-pronged attack aimed right at the heart of their case, this whole idea that they were good faith purchasers.
He argued there was no way they could be in good faith because they weren't just innocent bystanders. He alleged they knew about serious problems with the property's title and, even crazier, that they actively participated in rigging the auction process itself.
Now this is where a really interesting tactic comes into play. The plaintiffs kept repeating the phrase, Mr. Bass had notice, to create confusion. They're mixing up the simple notice of sale, the public announcement, with the legally critical idea of a buyer's notice of issues. By blurring those lines, they tried to distract from the most important question. Did they know about problems before they bought the property? Okay, this is where the case totally pivots. It goes from a legal debate to this frantic race against the clock, and it really shows the incredible pressure put on someone representing themselves against a whole corporate law team. Just look at this timeline. It's intense. The plaintiffs filed their reply, and with it, new evidence, on a Friday. Bass had to scramble all weekend to file 3 detailed responses on Monday, less than 24 hours before the hearing. It was basically a procedural minefield.
And, as this legal expert points out, the system itself can create an imbalance. See, when a plaintiff drops new arguments at the very last minute, the rules often don't give the defendant a clear way to respond. It's a serious procedural disadvantage.
So in that last-minute reply, the plaintiffs made what you could definitely see as a critical admission. But because of a very strict procedural rule, the court never even got to consider Bass's analysis of it.
So the plaintiffs framed this as just smart, normal due diligence. But Bass argued it was a flat-out admission of collusion, getting non-public, inside information from the trustee to get an unfair advantage and basically prearrange the outcome of a public auction.
And this became the central, unanswered question of the entire case. Does contacting the trustee to get the lender's opening bid, information that the general public doesn't have, disqualify you from being a, quote, purchaser in good faith? The court never got to decide.
This slide really shows a stunning contrast. So the plaintiffs cited this other case, Breckenridge, to argue that what they did was totally normal. But when you look at them side by side, their behavior was the exact opposite of what was considered legal practice in that case. In Breckenridge, there was no pre-bid coordination. Here, there was. But the real smoking gun? Bass alleged the plaintiff showed up with pre-printed cashier's checks for the exact final bid amount. How is that even possible in a truly competitive auction?
And with that one statement from the judge, bam, the procedural wall came crashing down. The judge, strictly applying the court rules, refused to even look at Bass's arguments about that pre-auction call or the pre-printed checks. The evidence was right there.
but the rules prevented it from ever being seen.
So that ruling meant this case wasn't just about one property anymore. It blew up into being about these fundamental questions of fairness and access to justice in our legal system.
So here's the crucial point. The legal framework itself can be tilted. Yeah, the laws are designed to protect buyers and provide finality, but that creates this massive uphill battle for a homeowner who's trying to prove something went wrong. And these procedural rules, they can turn that hill into a mountain that's almost impossible to climb. And this is the very question that came out of this whole procedural showdown, a question Jeremy Bass took all the way to the Idaho Supreme Court. It leaves all of us to wonder, in this search for efficiency in our courts, where do we draw the line to make sure there's real, substantive justice for everyone, no matter what their resources are?